FAR 15.206(e), Cancellation of solicitation. In a negotiated procurement, an agency has broad authority to decide whether to cancel a solicitation, and to do so, need only establish a reasonable basis. Thus, we have consistently explained that an agency need only establish a reasonable basis to support a decision to cancel a solicitation. A reasonable basis to cancel exists when, for example, an agency concludes that a solicitation does not accurately reflect its needs. Moreover, an agency may properly cancel a solicitation regardless of when the information precipitating the cancellation first surfaces or should have been known. Where a protester has alleged that the agency's rationale for cancellation is but a pretext and that the agency's actual motivation is to avoid awarding a contract on a competitive basis or to avoid resolving a protest, we will closely examine the reasonableness of the agency's actions in cancelling the acquisition. Notwithstanding such closer scrutiny, and even if it can be shown that pretext may have supplied at least part of the motivation to cancel the procurement, the reasonableness standard applicable to cancellation of a solicitation remains unchanged. Our review of the record provides no basis to sustain the protest. Here, the agency reasonably determined that the solicitation, as issued, no longer met its needs. In this regard, following multiple discussions between personnel from the DOS Contracting Office and the Program Office in Mexico City, the agency decided to cancel the solicitation once it realized it needed a new requirement that would increase the scope of the statement of work. The agency arrived at this conclusion after reviewing the RFP and realizing that approximately 80% of the work in the RFP was no longer applicable to the agency's current requirement. For example, the agency determined that it now needed the addition of over 140 functional requirements of software development, which were critical to the completion of the biometric data exchange cloud infrastructure. DOS concluded that to meet the additional requirements that were identified, the solicitation would have to be amended to include tasks associated with the generation of administrative tools, reporting and analytical capabilities, and a web-based application for data aggregation. Furthermore, the agency concluded that due to the additional work required, changes would also need to be made to the key personnel requirements identified in the RFP. Finally, DOS also determined that it would be necessary to remove certain tasks from the solicitation's statement of work because those tasks were no longer needed. Ultimately, the contracting officer determined that awarding a contract based on the outdated solicitation would have resulted in the government paying for and receiving a project that did not meet the government's needs. Computer World Services Corporation B416042, May 22, 2018. The protesters maintain that the agency had no reasonable basis to cancel the solicitation and that the cancellation was a pretext to avoid further protests. According to the protesters, the evaluation errors it identified in its earlier protests could easily be addressed in all of 15 minutes by deeming certain aircraft unacceptable and awarding a contract to Evergreen for its 6 aircraft. We have considered all of the protesters' arguments in support of their position and find that none provides a basis to sustain the protest. In a negotiated procurement, an agency has broad authority to decide whether to cancel a solicitation, and to do so, need only establish a reasonable basis. Thus, we have consistently explained that an agency need only establish a reasonable basis to support a decision to cancel a solicitation. A reasonable basis to cancel exists when, for example, an agency concludes that a solicitation does not accurately reflect its needs. Moreover, an agency may properly cancel a solicitation regardless of when the information precipitating the cancellation first surfaces or should have been known. However, where a protester has alleged that the agency's rationale for cancellation is but a pretext that the agency's actual motivation is to avoid awarding a contract on a competitive basis or to avoid resolving a protest, we will closely examine the reasonableness of the agency's actions in cancelling the acquisition. Notwithstanding such closer scrutiny, and even if it can be shown that pretext may have supplied at least part of the motivation to cancel the procurement, the reasonableness standard applicable to cancellation of a solicitation remains unchanged. Cancellation of a procurement is reasonable where the agency determines that it no longer has a requirement for the item solicited, or where the agency discovers an existing contract for its requirement would be more advantageous to the government than continuing with the procurement. As explained above, the agency first selected 6 firms for awards on December 15, 2016, more than 5 months before the first exclusive use period was to begin. Several protests followed, culminating in a lengthy supplemental protest filed on April 17. In this filing, Evergreen raised numerous protest allegations challenging various aspects of the evaluation of most of the awarded aircraft, as well as DOI's evaluation of Evergreen's proposal and the agency's best value award determination. The agency concedes that certain of these allegations had merit, and, consequently, it decided during the week of April 24, less than a month before the first exclusive use period was to begin, that some form of corrective action was warranted. The agency acknowledges that a re-evaluation of the tens of aircraft proposed by the 15 offerors could have resulted in a different award decision. However, as more fully discussed below, the agency maintains that it simply did not have sufficient time to conduct a re-evaluation of proposals and make a new best value determination prior to its need for seat aircraft at the start of the 2017 fire season. Because, according to the agency, a re-evaluation was not feasible given the short timeframe, and another procurement vehicle was in place to fulfill its needs, the agency cancelled the solicitation. Thus, the record shows that impetus for the cancellation of the solicitation was Evergreen's supplemental protest. As a general rule, agencies have broad discretion to take necessary steps to ensure fair and impartial competition. Moreover, an agency's decision to cancel a solicitation in response to a protest is not per se unreasonable, nor does it demonstrate that the decision to cancel was made only to avoid the resolution of a protest, as the protesters suggests. We will not find a cancellation of a solicitation to be unreasonable solely because it was prompted by a protest. The cancellation of a solicitation is reasonable where a lack of funding justified the decision to cancel, even if the decision to cancel was prompted by a protest. Thus, the question is not what the agency would have done absent a protest, as Evergreen insists, but rather, after consideration of the entirety of the agency's justification for the cancellation, whether the cancellation was reasonable. Here, in deciding to cancel the solicitation, the agency explains that it could not afford to sit on its hands and wait for a re-evaluation before it could begin issuing task orders and deploying aircraft to meet DOI's urgent firefighting needs. In this respect, the agency maintains that a second re-evaluation would have pushed the exclusive use contract start date well into fire season, which would have been an unacceptable result. The agency explains that it cancelled the solicitation because it had an immediate need to prepare aircraft for deployment and assign agency personnel to locations spread across the country to manage the aircraft for aerial fire suppression. Consequently, the agency made the decision to acquire its urgent requirements under a different available procurement vehicle, the on-call contracts, rather than take the risk that the exclusive use contracts would be available on time. The agency further asserts that the exclusive use procurement is no longer beneficial to the agency. In this regard, as seat aircraft are deployed under the on-call contracts, less funding is available for aircraft under the exclusive use contracts, and the agency's requirements are diminished. Significantly, as highlighted above, the exclusive use procurement was structured such that the contracts required that DOI issue at least one order for each of the 33 aircraft for a full 100-day period, the first of which was to begin May 20. According to the agency, if the contracts could not be awarded and task orders issued in time for the initial exclusive use period, then the minimum guarantee could not be met without either creating unnecessary additional overlap between exclusive use periods or having the exclusive use periods extend beyond fire season, when seat services are not necessary. As a result, the agency asserts that, given the delay in the start date, it no longer had a requirement for the guaranteed minimum under the exclusive use contracts. On this record, we find DOI's rationale for canceling the solicitation to be justified, reasonable, and supported by the record. Evergreen's supplemental protest identified flaws in the procurement that warranted corrective action. Without sufficient time to perform a complete re-evaluation of proposals, the agency chose to begin fulfilling its fire season requirements using a different contract vehicle. By the time any reevaluation could have been completed, the agency would no longer have a need for the guaranteed minimums under the exclusive use contracts. Thus, while the cancellation was prompted by a bid protest, the agency established that the exclusive use solicitation no longer reflected its needs, which is a reasonable basis to support a decision to cancel a solicitation. Cancellation is not a pretext to avoid resolving a protest where the agency's requirements were time-dependent and had changed due to the pendency of the prior protest. Cancellation of solicitation following corrective action is reasonable where the solicitation no longer reflected the agency's needs. The protesters disagree with the agency as to whether a reevaluation would have been time-consuming and, consequently, time-prohibited. According to Evergreen, the agency had ample time to perform a reevaluation and make a new award determination. Evergreen points out that the reevaluation conducted during the agency's earlier corrective action allegedly took less than a week. The protester also highlights other contract-related activities that the agency had undertaken following its decision to cancel the solicitation. As noted above, the agency maintains that a reevaluation would have taken a substantial amount of time and was not feasible, especially due to the onset of fire season. The agency asserts that the initial reevaluation which it represents took more than a month was much simpler than the reevaluation that would have been necessitated by Evergreen's supplemental protest. The agency further explains that because mistakes were made in the first and second evaluation, the third evaluation would likely take more time to get things right. The agency outlines what a reevaluation would have entailed. The geographically dispersed evaluation team members would have to meet in one location and review all 15 proposals again. The evaluators would then reassign technical strengths and weaknesses, ensuring consistency between offers, and thoroughly document the advantages and disadvantages of proposals justifying the ratings. Considering Evergreen's protest allegations, the technical experts would have to recalculate the aircraft capacity for each of the more than 60 aircraft proposed. Then, the evaluation team would need to document numerous trade-off analyses. The reevaluation, which would have been the third for the acquisition, would have also required additional internal reviews, including a lengthy legal review as well as approval from DOI's Acquisition Process Advisory Council. Moreover, contrary to Evergreen's position, DOI could not simply make an award to Evergreen for its 6 aircraft and then ignore all of the other alleged evaluation flaws. The agency further explains that by the time it decided to cancel the solicitation, members of the evaluation team were already busy preparing for the impending fire season. In this respect, participants of the evaluation team have other primary responsibilities within their own organizations, i.e., serving as pilots and air attack supervisors, and would have needed management permission to participate in a reopened source selection process. The agency lays out a list of essential firefighting-related tasks that occupied the evaluators' time in the weeks preceding fire season. The agency represents that these other responsibilities and tasks, some of which required significant travel across the country and significant overtime hours, made it impracticable for the evaluation team to meet and perform a reevaluation prior to the first exclusive use period. In light of the detailed explanation provided by the agency, we have no basis to reject DOI's assertion that it was not in the government's interest to pull the evaluators from their critical work to perform the reevaluation. While Evergreen believes that the evaluation errors it alleged in its protest could have been easily and quickly addressed by the agency explains why this was not the case. Simply put, we find convincing the agency's explanations that once fire season was active, it was not realistic to gather the evaluation team back from their primary duties to reanalyze and reevaluate proposals. The protesters next assert that cancellation was unnecessary because the agency could have used both the exclusive use and on-call contract vehicles during the 2017 fire season, relying on the on-call contracts in the short term and switching to the exclusive use contracts when the new awards were made. Here, too, the agency provides a reasonable response. DOI explains that once it issues task orders for a specific firefighting effort, it becomes impracticable for the agency to transfer those requirements to a different contractor. The agency points to significant duplication of costs stemming from the mobilization and demobilization costs of multiple contractors. In addition, the active firefighting aircraft ostensibly procured under an on-call contract would have to be replaced with a new crew under the exclusive use contract that did not possess the specific operational knowledge and experience of the previous crew. The agency would thus have to spend effort ensuring the new aircraft crews were up to speed and adequately prepared to safely respond to the fires. Given these considerations, we agree with the agency that the operational disruption of changing contract vehicles mid-operation would have been significant and not in the agency's interest. Moreover, as explained above, as agency funds were expended under the on-call contracts, the agency would not be able to fulfill the minimum guarantee under the exclusive use contracts. Ultimately, a protester's disagreement with the agency's judgment concerning its needs and how to best accommodate them does not demonstrate that the agency's judgment was unreasonable. We also have previously recognized that avoiding procuring duplicative services may reasonably support a decision to cancel a solicitation. We also find unpersuasive the protester's assertion that the agency should be required to simply make new awards under the solicitation in time for the 2018 fire season, or that cancellation was unreasonable because the agency will still need fire suppression services throughout the IDIQ contract's 5-year periods of performance. First, the agency explains that the minimum guarantee was established based on the agency's budget and anticipated needs for the 2017 fire season, and that it obtained funding sufficient to meet the minimum guarantee in 2017. DOI represents that while it will likely want exclusive use seat services in upcoming summers, it does not yet know what its budget will be. In this respect, if it were to make a new award decision when convenient and delay performance until the 2018 fire season, then the agency would be obligating itself to procure 33 aircraft for 100-day periods for the 2018 fire season. We recognize that the contractors would prefer this compromise. However, the agency understandably asserts that this is a materially different bargain that the agency does not wish to undertake. We see nothing improper with the agency's explanation in this regard. In addition, as the agency notes, it was under no obligation to exercise the options or issue any orders above the mandatory minimum. The fact that the contracts, with all options exercised, would have covered a 5-year period does not demonstrate that the cancellation was not justified. Lastly, to be clear, nothing in the record supports Evergreen's assertion that the cancellation was a pretext to avoid awarding the firm a contract. On the contrary, the contracting officer notes that Evergreen is considered a capable, qualified contractor and that the agency would have been happy to make an award to Evergreen if such an award were deemed to be in the government's best interests. The contracting officer further explains that the agency has worked with Evergreen for many years and DOI anticipates that Evergreen will receive orders under its on-call contract this summer. Absent anything in the record to support Evergreen's charge and given that government officials are presumed to act in good faith, we find that the allegation of animus or bias is unsupported and, thus, unmeritorious. In sum, the record confirms that the agency's decision to cancel the solicitation was prompted by Evergreen's supplemental protest. Nevertheless, in light of the time-sensitive nature of the required fire suppression support services, the RFP's restrictive minimum guarantee that would prove difficult for DOI to meet if it were to conduct a re-evaluation of proposals, and the fact that another contract vehicle was available for the agency to acquire seat aircraft for the 2017 fire season, we find that the cancellation was reasonable based on the justifications advanced by the agency. Henry's Aerial Service Incorporated, Evergreen Flying Services, Inc. B414238.7, B414238.9, August 10, 2017. In a negotiated procurement, such as this one, a contracting agency has broad discretion in deciding whether to cancel a solicitation. Thus, we have consistently explained that an agency need only establish a reasonable basis to support a decision to cancel a solicitation. A reasonable basis to cancel exists when, for example, an agency concludes that a solicitation does not accurately reflect its needs. Moreover, an agency may cancel a solicitation regardless of when the information precipitating the cancellation first arises. This is so, even when the cancellation occurs during the pendency of a protest. Where, as here, a protester argues that the agency's rationale for cancellation is but a pretext, that is, that the agency's actual motivation is to avoid awarding a contract on a competitive basis or to avoid resolving a protest, we will examine the reasonableness of the agency's actions in cancelling the procurement. Nevertheless, the reasonableness standard applicable to cancellation of a solicitation remains unchanged. The DOS explains that, because of T.N. Walker's earlier protest to our office, the agency was required to stay contract award and performance, in accordance with applicable procurement regulations. Consequently, even if T.N. Walker's earlier protest had been denied, the contractor would not be able to complete the first survey wave prior to Ramadan. As the contracting officer further explains, the government now has to re-examine its needs, since there is no value in conducting 2 waves of surveys between Ramadan and the beginning of the winter season. Winter weather conditions make face-to-face fieldwork more challenging from late October and onward. The government typically conducts each survey wave 6 months apart. If we were to conduct the waves too close together, it is unlikely that the public's attitude changed dramatically in such a short span, with the exception of any major events. We find that DOS's rationale for cancelling the solicitation was not a pretext to avoid awarding a contract on a competitive basis or to avoid resolving a protest, as T.N. Walker surmises. Rather, the record reflects that T.N. Walker's earlier protest and the attendant stay of contract award and performance caused the agency's requirements to change. Specifically, due to the challenge to the solicitation, the agency was unable to make a contract award. Consequently, the contractor would not be able to complete the first wave of fieldwork prior to Ramadan, and 2 waves of fieldwork, properly spaced apart, prior to the Afghan winter season. In sum, as the agency's public opinion survey requirements could not be achieved in the necessary timeframe, and had therefore changed, the agency had a reasonable basis to cancel its solicitation. T.N. Walker contends that the agency cannot argue that the time has passed to satisfy the requirement, thereby justifying cancellation, but simultaneously also claim a need to resolicit for the same requirement. The protester alleges that such rationales are inconsistent and conflicting ones, and cites to our decision in Walker Development and Trading Group in support thereof. In Walker Development, we found the agency failed to produce a report that coherently addressed the agency's rationale for the cancellation of the solicitation, and therefore concluded that the record did not establish that the agency had a reasonable basis for its solicitation cancellation. We find T.N. Walker's reliance on our Walker Development decision to be misplaced, as the facts in the current protest are inapposite to those in the cited decision. Here, there is nothing inconsistent or conflicting about the agency's rationale for the cancellation of the solicitation. As detailed above, DOS reasonably determined that its needs for a current Afghan public opinion survey could not be achieved in the necessary timeframe and had therefore changed. The agency also simultaneously decided to conduct market research to guide its future procurements for such services. The sources sought notice is not itself a solicitation. It states that this is not a solicitation announcement. No contract will be awarded in this announcement. This request for capability information does not constitute a request for proposals. Likewise, the agency's decision to plan for possible future Afghan public opinion survey requirements does not alter the fact that the present Afghan public opinion survey requirement had changed. There is simply no requirement, as the protester suggests, that the agency amend a solicitation that no longer reflects its requirements, only to leave it open indefinitely for possible future needs. T.N. Walker B414623.2, B414623.3, July 10, 2017. In April 2017, the agency responded to the various protests, submitting individual reports addressing each protester's assertions separately. Among other things, the agency reports included the Technical Evaluation Report, Price Evaluation Report, and Best Value Trade-off Analysis that the agency represented as having been the basis for the SSAS March 6 source selection decisions. In the protesters' comments, a question was raised as to whether the documents supporting the agency's source selection decisions filed with the agency reports AR, had been prepared or revised after the March 6 decisions were made. Our office requested that the agency respond to the comments. In a letter to our office dated May 1, agency counsel disclosed that, based on her review of the agency reports, she had discovered that the price evaluation report is incorrect and that some of the information provided in the AR was prepared or changed after award. The agency's post-award changes to the original price evaluation documents included the insertion of a multi-page table, as well as the creation of several memoranda regarding the price realism evaluation methodology and findings. In the May 1 letter, agency counsel further disclosed that after award, the agency revised the technical evaluation report and the best value trade-off analysis. With the May 1 letter, the agency provided what it asserted was the version of these documents that existed at the time of the source selection decisions. These newly produced documents showed that the agency's post-award alterations resulted in substantial changes to the total number of pages in each of the altered documents. Following the agency's disclosures, this office consolidated all of the protests and conducted several conference calls with counsel for the parties, expressing concern regarding the agency's submission of altered documents, and advising the parties that GAO intended to conduct a hearing to address various matters including the agency's preparation and submission of the altered documents. On May 25, we issued a hearing notice that stated, among other things, GAO will conduct a hearing in connection with the above-referenced protests. That hearing will begin at 9 a.m. on Wednesday, May 31, 2017. In addition to addressing the agency's post-award alteration of documents and the submission of those documents to GAO, the hearing will address the following issues: 1. The agency's best value determinations and the cost/technical trade-offs on which those determinations were based; 2. The agency's price realism evaluation; and 3. The agency's technical evaluation. On May 26, the agency advised our office that it intended to take corrective action by terminating all of the contract awards and canceling the procurement. In its notice of corrective action, the agency discussed its post-award alterations of the record and the impact of those actions on the integrity of the procurement as follows. DHS has previously acknowledged that documents had been created after award, specifically additional price realism memoranda and a memorandum detailing the methodology it used to evaluate price realism, and changed documents after award, specifically the technical evaluation report and BVTA. Given the additions and the changes to documents after award, DHS had previously submitted to the Government Accountability Office as representative of the record at the time of award. DHS has determined that the evaluation process and documents do not meet DHS standards for award. The agency further discussed other matters including the solicitation's failure to accurately reflect the agency's needs, and flaws in the agency's evaluation and source selection process that led to the decision to take corrective action, stating, DHS has determined that the evaluation criteria and adjectival ratings did not permit evaluators to reasonably evaluate the offerors and assign appropriate ratings based upon the evaluation criteria. DHS has also determined that the evaluation of the offerors may have resulted in unequal treatment of offerors' weaknesses and risks. This is partially due to the adjectival ratings that were used, but also due to the evaluation process used to evaluate and assess offerors during the technical challenge exercises. DHS has identified issues in the price evaluation report and best value trade-off analysis which do not adequately support its award decisions. The methodology by which the price evaluation team evaluated price realism is not identified in the PER. Nor is it evident in the PER itself what DHS reviewed and evaluated to determine whether prices were reasonable and realistic. DHS did not require offerors to provide sufficient information to assess whether the prices proposed were realistic to perform work on task orders at the top secret/sensitive compartmented information level or provide the necessary information to assess whether the rates proposed met the requirements. Within the BVTA, DHS has determined it did not conduct a reasonable trade-off of offerors to determine which offerors represented a best value to DHS. In addition to the above, DHS has determined that substantial modifications to the requirements would need to be made to ensure that Flash meets DHS evolving mission needs. Through the process of awarding Flash, DHS has learned more about its needs and the ways that Flash does not meet them. The Flash requirements, while extensive, do not include services that DHS now sees as critical components for the success of this type of vehicle. The inclusion of these additional required services would require a significant change to what information offerors would be required to provide and how DHS would evaluate offerors. DHS has determined that cancellation of the Flash solicitation is the only viable option to address the many issues that DHS has identified as problems with the requirement and the record. When an agency terminates a contract and cancels the underlying solicitation, the agency's actions render a protest challenging the contract award academic. A reasonable basis to cancel a solicitation exists when, for example, an agency determines that the solicitation does not accurately reflect its needs. Here, we view the agency's termination of the contract awards and cancellation of the underlying solicitation as rendering the protests academic. Accordingly, the protests are dismissed. The protester recognizes that, in a negotiated procurement, an agency may cancel an existing solicitation where it has a reasonable basis for doing so, but argues that in this instance the agency lacked a reasonable basis for its decision to cancel. The protester also contends that the award of a contract to Railroad Cleaners, a firm which it contends always receives these laundry contracts, for closed competition. The agency initially argued that it canceled the solicitation because the solicitation listed a minimum amount of $1 million for the IDIQ contract to be awarded, and that Walker's quotation was under that amount. The agency's rationale for canceling the solicitation changed somewhat in a later filing where the agency argued that as the minimum dollar setting was $2,500,000, we would not be able to make the award to any vendor that submitted a quote under that amount, as we were guaranteeing the contractor that at least $2,500,000 would be spent that year. There is no additional explanation regarding the reasonableness of the cancellation. We find that the agency failed to produce an agency report that coherently addressed the agency's rationale for the cancellation of the solicitation. Rather, as stated above, the agency submitted undated statements from its contract specialist that provided conflicting rationales for the cancellation. In addition, documentation provided by the agency does not indicate that the guaranteed minimum was $2,500,000. Our office afforded the agency numerous opportunities to provide its rationale for the cancellation, of which the agency failed to avail itself. In the absence of an adequate agency record to support its actions, and in the absence of any reasonable explanation for its actions, we are left with no option but to make an adverse inference in this matter. We therefore conclude that the record here does not establish that the agency had a reasonable basis for the cancellation of the solicitation and sustain the protest. Regarding the alleged award of a contract to Railroad Cleaners, it appears that the agency was using FAR Clause 52.217-8 to extend the performance period of a previously awarded contract. In essence, Walker is challenging the agency's decision to extend Railroad Cleaners' contract rather than issue a competitive solicitation, an agency decision which is appropriate for our review. In this regard, the agency never addressed our concern that the solicitation number for the cancelled solicitation and the solicitation number for the contract awarded to Railroad Cleaners were identical. To date, the agency has provided no information regarding the contract with Railroad Cleaners, leaving the record unclear about what the agency did or why. Therefore, we also sustain this basis of protest. We sustain this protest because the record fails to demonstrate that the agency had a reasonable basis for canceling the solicitation or for extending the period of performance for the contract of Railroad Cleaners. We recommend, if feasible, reinstating the solicitation, recognizing that the agency may need to amend the solicitation to address concerns about the intended value of the anticipated contract. We further recommend that the agency terminate Railroad Cleaners' contract once the new award has been made. We also recommend that Walker be reimbursed for the reasonable costs of filing and pursuing the protest. The protester's certified claim for costs, detailing the time spent and the costs incurred, must be submitted to the agency within 60 days after receipt of this decision. Walker Development and Trading Group, Inc. B413924, January 12, 2017. Regarding Medfinity's challenge to the cancellation decision, our office has held that a contracting agency need only establish a reasonable basis to support a decision to cancel an RFQ. A reasonable basis to cancel exists when, for example, an agency determines that a solicitation has been drafted without sufficiently detailed evaluation criteria to permit a fair and equal evaluation of all quotations. Where, as here, a protester alleges that the agency's rationale for cancellation is a pretext, that is, that the agency's actual motivation is to avoid awarding a contract on a competitive basis or to avoid deciding a protest on the merits, we will closely examine the reasonableness of the agency's actions in canceling the acquisition. Notwithstanding such closer scrutiny, however, and even if it can be shown that personal animus or pretext may have supplied at least part of the motivation to cancel the procurement, the reasonableness standard applicable to the cancellation of a solicitation remains unchanged. Here, we find that HHS had a reasonable basis to cancel the solicitation considering the RFQ's failure to include detailed specifications that reflected the agency's needs. Under FAR 11.104, solicitations that are conducted on a brand name or equal basis must include, in addition to the brand name, a general description of those salient physical, functional, or performance characteristics of the brand name item that an equal item must meet to be acceptable for award. The RFQ at issue here, however, did not list salient characteristics for 3 out of the 4 equipment items being solicited and instead merely provided the brand name. Additionally, with respect to the 4th item, the OCT system, the agency explained that the salient characteristics listed had simply been copied from a website without any consideration as to whether such characteristics reflected the agency's needs. Mirroring the lack of detail in the solicitation, the agency's technical evaluation included no analysis of whether Medfinity's proposed solution met the salient characteristics provided for in the RFQ. In reviewing this record following pro-AIMS protest, HHS determined that it needed to terminate Medfinity's contract for convenience, pending the development of salient and essential physical characteristics in order to effectively develop a requirements package that adequately represents the government's need while also allowing for adequate competition. Notwithstanding this stated rationale, Medfinity contends that the agency's real reason for canceling the solicitation was to avoid having to award the contract on a competitive basis. In this regard, Medfinity points to an email sent by the contract specialist, which states that HHS would be using ECAT, a government-wide acquisition contract, while HHS redefines its requirements. Medfinity asserts that this establishes that the agency has no intention of resoliciting the requirement. We disagree with the protester's contention that the contract specialist's statement establishes that the agency's real reason for canceling the solicitation was to avoid awarding a contract on a competitive basis. As discussed above, the evaluation record evidences that the salient characteristics for each equipment item were either missing or did not reflect the agency's needs. Considering this, HHS was not able to use the existing RFQ to evaluate vendors in a fair or equal manner in order to meet its needs. Accordingly, we cannot conclude that the decision to cancel the solicitation was unreasonable or was made on the basis of pretext. Medfinity LLC B413450, September 9, 2016. INALAB challenges the agency's decision to cancel the procurement. The protester contends that the agency's rationale for canceling the RFP is a pretext to avoid resolution of the protest. INALAB also alleges that the cancellation is unreasonable because DOI has failed to demonstrate that in-house performance would result in cost savings and efficiencies as compared with award under the solicitation. Based upon our review of the record, we find that the agency's cancellation was not unreasonable. As a general rule, our office does not review agency decisions to cancel procurements and instead perform the work in-house, since such decisions are a matter of executive branch policy. However, where, as here, a protester argues that the agency's rationale for cancellation is but a pretext that the agency's actual motivation is to avoid awarding a contract on a competitive basis or to avoid resolving a protest. We will closely examine the reasonableness of the agency's actions in canceling the procurement. Here, the agency states that, during the pendency of the protest, it determined that it could perform the requirement with government employees. In this respect, the agency explained that, on or around May 11, 2016, FMD learned that a current GS-14 level employee had significant recent OBIEE experience gained from his duties at his former place of employment. On or around May 18, 2016, FMD learned that consulting-type services from Oracle are available under previously purchased software licenses. Through these available services, Oracle will provide advice regarding the best use and configuration of the licensed software within the FMD environment at no additional cost. Once the in-house expertise and existing support from Oracle was discovered, FMD began exploring the potential benefits to performing the required need exclusively with in-house resources. On or about May 23, 2016, the agency preliminarily determined that existing resources could, in fact, be leveraged by utilizing the aforementioned GS-14 level employee full-time, an existing GS-13 level employee full-time, an existing GS-14 level employee part-time, and an existing GS-15 level employee as needed. In addition to the existing employees, FMD plans to hire one GS-15 level employee. The existing government staff has been valued at $208,772 per year, and the planned additional staff member is estimated to cost $143,009 per year. The government estimate for the initially planned contracted effort as $821,066.22, which suggests that the government will save $469,285.80 by performing the work in-house instead of obtaining contractor support. Leveraging the services available under the previously purchased Oracle licenses also allows FMD to eliminate some degree of waste by fully utilizing an existing resource that has already been paid for. INALAB challenges the underlying basis of the agency's cancellation, asserting that DOI unreasonably concluded that in-house performance would result in a cost savings. Specifically, the protester questions DOL's last-minute discovery of the purported capability to accomplish the required work using agency resources, asserting that DOL has not shown that the cancellation would lead to cost savings, as it now claims, or that it will be able to accomplish the work. The record shows that, in response to the protest, the agency began an internal inquiry for an alternate method of accomplishing the work. That inquiry led to the conclusion that the agency could accomplish at least some of the work through consulting-type services from Oracle that are available under previously purchased OBIEE software licenses. A contracting agency need only establish a reasonable basis to support a decision to cancel an RFQ. A reasonable basis to cancel exists when, for example, an agency determines that a solicitation does not accurately reflect its needs. Here, the agency has determined that at least some of the effort currently encompassed by the solicitation can be accomplished at no additional cost to the agency. This is sufficient for us to conclude that the agency's cancellation of the solicitation is reasonable. In any event, to the extent the protester argues that the newly discovered in-house capability constitutes a new basis for canceling the solicitation that was not identified until after the solicitation had been cancelled, our office has held that a new or additional rationale justifying the cancellation of a solicitation provided by an agency during the development of a protest is acceptable so long as it would have supported cancellation had it been advanced originally. In this regard, an agency may properly cancel a solicitation no matter when the information supporting the cancellation first surfaces or should have been known, even if the solicitation is not cancelled until after proposals have been submitted and evaluated, or even if discovered during the course of a protest. Our conclusion is not changed by INALAB's assertion that the agency's proffered rationales for cancellation are merely a pretext to avoid scrutiny of the agency's actions. Government officials are presumed to act in good faith and, where a protester contends that contracting officials are motivated by bad faith, it must provide convincing proof, our office will not attribute unfair or prejudicial motives to procurement officials on the basis of inference and supposition. Although the agency did not discover its in-house capabilities until after the procurement was protested, the record does not provide convincing proof that the agency acted in bad faith. The protester claims that the anticipated cost savings are illusory and that the agency has underestimated the manpower required to perform the work in-house. While we agree that the agency's savings estimate for personnel expenses may not account for all of the relevant costs, any calculation error does not diminish the fact that DOI has also identified a separate source of cost savings in the use of existing Oracle services. In sum, we find no basis to question the agency's conclusion that in-house performance would result in some cost savings or provide other benefits. Accordingly, we find that the agency's cancellation was reasonable. Cancellation of the solicitation in order to perform the work in-house is not objectionable where the agency articulated a reasonable basis for its decision. Inalab Consulting Incorporated, Solutions by Design 2, LLCB 413044, August 4, 2016. In a negotiated procurement, such as this one, a contracting agency has broad discretion in deciding whether to cancel a solicitation and need only establish a reasonable basis for doing so. A reasonable basis to cancel exists when, for example, an agency determines that a solicitation does not accurately reflect its needs. An agency properly may cancel a solicitation no matter when the information precipitating the cancellation first arises, even if it is not until offers have been submitted and evaluated. Where, as here, a protester alleges that the agency's rationale for cancellation is a pretext, that is, that the agency's actual motivation is to avoid awarding a contract on a competitive basis, we will closely examine the reasonableness of the agency's actions in canceling the acquisition. Notwithstanding such closer scrutiny, however, the reasonableness standard applicable to the cancellation of a solicitation remains unchanged. We find that the record reasonably supports the agency's decision to cancel the RFP because it no longer accurately reflected the customer's needs. Supply Corp Incorporated B411015.8, May 27, 2016. Sealift asserts that the agency's corrective action is overly broad and unreasonable given the prior protest allegations. In this regard, Sealift maintains that the agency's corrective action fails to address the mishandling of the small business tiered evaluation under the original solicitation. The agency argues that its choice of corrective action, i.e., canceling and reissuing the solicitation, was reasonable in light of its reason for taking corrective action, i.e., that the RFP was ambiguous about how the tiered evaluation of proposals would be performed. As a general rule, agencies have broad discretion to take corrective action where the agency has determined that such action is necessary to ensure fair and impartial competition. The details of implementing the corrective action are within the sound discretion and judgment of the contracting agency, and we will not object to any particular corrective action, so long as it is appropriate to remedy the concern that caused the agency to take corrective action. Moreover, our review is generally limited to whether the agency's corrective action is appropriate to remedy the flaw which the agency believes exists in its procurement process, not whether the agency's corrective action remedies the flaws alleged in an earlier protest where no decision on the merits was issued by our office. Where an agency discovers that a solicitation is vague or ambiguous as to how the procurement will be conducted, a proper remedy is the cancellation and reissuance of the solicitation. Further, we have recognized that the possibility that a contract may not have been awarded based on a fair determination of the most advantageous proposal has a more harmful effect on the integrity of the competitive procurement system than does the possibility that the original awardee will be at a disadvantage in a reopened procurement because its price has been exposed. On the record here, we see no basis to object to the agency's corrective action. As a preliminary matter, as set forth above, our office never determined the merits of Sealift's earlier protest. Thus, our review here is limited to whether the Navy's choice of corrective action is appropriate to remedy the flaw which the agency believes exists in the procurement process. Further, as Sealift was not the original awardee for this procurement and its price was not exposed, Sealift is not at a competitive disadvantage in the reopened procurement. The agency explains how it determined that the RFP was ambiguous as to the tiered evaluation. In this regard, the agency intended that the tiered evaluation would only be conducted based on the initial proposals. Consequently, the agency did not relook its unrestricted competition decision after receipt of FPRs, even though there existed 2 or more small business proposals that were technically acceptable and competitive in terms of price, quality, and delivery. The solicitation, however, was silent as to when and how the agency would conduct its tiered evaluation of offers. Having found that the procedures set forth in the RFP for making the tiered evaluation decision were ambiguous, the contracting officer determined that the solicitation required correction. In light of the passage of time, the RFP was issued in January 22, 2015, with a closing date of March 13. The contracting officer determined that the appropriate remedy was canceling and reissuing rather than amending the earlier solicitation. Under the circumstances, we conclude that the agency reasonably determined that it should cancel the RFP and resolicit after clarifying its tiered evaluation process. In sum, although Sealift would undoubtedly prefer the Navy make award to it as the highest-rated small business concern, or amend the prior solicitation and restrict competition to the initial offerors, we find Sealift's disagreement with the agency's rationale for canceling and reissuing the solicitation does not provide a basis on which to sustain the protest. The protest is denied. Sealift, Inc. B412041.2, Dec 30, 2015. The protester contends that the agency's decision to cancel the RFQ was unreasonable. Relying on information presented in its debriefing, the protester claims that the agency miscalculated the dollar value of its prior contracts, which led to the agency's determination that it lacked sufficient experience to perform the solicited RFQ requirements. Precise Management also challenges the agency's finding that its proposed price was unreasonably high. A contracting agency need only establish a reasonable basis to support a decision to cancel an RFQ. A reasonable basis for cancellation exists, and cancellation is appropriate when none of the proposals received were evaluated as technically acceptable. Additionally, if an agency cannot purchase at a fair and reasonable price, as required by the Federal Acquisition Regulation, then cancellation is warranted. Price must be fair and reasonable. A determination of price reasonableness is a matter of agency discretion, involving the exercise of business judgment, which our office will not question unless it is shown to be unreasonable. In determining price reasonableness, an agency may consider a number of factors, including prior contract history and the government estimate. In this regard, we have found cancellations proper where the protester's price exceeded the government estimate by as little as 7.2%. We find the cancellation here was reasonable. As discussed above, none of the proposals received were technically acceptable and therefore all were ineligible for award. We recognize that Precise Management generally disagrees with the evaluation of its proposal under the technical experience subfactor. Nonetheless, we need not resolve this issue since the record reflects that the agency also found the proposed prices unreasonable. Although the protester challenges the agency's determination that its proposed price was unreasonably high, we have no basis to find the agency's evaluation in this regard unreasonable. Precise Management essentially argues that its price could not have been unreasonable since it was lower than the incumbent's price for pest control services at Fort Jackson, information which the protester obtained through a Freedom of Information Act request. The record, however, reflects that the protester's comparison to the prior contract's pricing is misplaced. The agency explains, and the protester does not dispute, that the incumbent contract was an indefinite delivery/indefinite quantity contract with 24 different contract line items, whereas the cancelled solicitation has only 3 fixed price line items. In addition, the agency notes that the price cited by the protester for the incumbent contract reflected the IDIQ contract's maximum dollar value. It did not represent the actual contract expenditures. According to the agency, many of the contract line items under the incumbent contract had maximum dollar values that were never utilized. As previously explained, the agency compared the protester's proposed prices to the government estimate and the current bridge contract pricing, i.e., current market climate, to determine the reasonableness of precise management's proposed prices. According to the agency, the pricing under the bridge contract provided the best basis for determining price reasonableness since the bridge contract's pricing structure was the same as the cancelled solicitation's pricing structure and reflected the most recent historical prices for the same or similar services. Given that the protester's prices exceeded the most current bridge contract prices by a significant amount, we have no basis to conclude that the agency acted unreasonably when it concluded that the protester's offered price was unreasonably high. Integrity argues that the VA's cancellation was improper because it was in response to two untimely agency-level protests. The protester also contends that the agency-level protests lacked merit because to the extent there were any questions regarding the square footage of the area to be cleaned under this RFQ, they were addressed in the questions and answers. For the reasons discussed below, we find no basis to sustain the protest. As a general rule, in a negotiated procurement, the contracting agency need only demonstrate a reasonable basis to cancel a solicitation after receipt of proposals, as opposed to the compelling reason required to cancel an IFB after bids have been opened. The standards differ because, in procurements using sealed bids, competitive positions are exposed because of the public opening of bids, while in negotiated procurements there is no public opening. Additionally, our office has stated that cancellation of a solicitation other than an IFB is proper, even after one or more of the offerors' prices have been revealed, where the agency has a reasonable basis to cancel, and the record contains plausible evidence or a reasonable possibility that a decision not to cancel the solicitation would be prejudicial to the government or the integrity of the procurement system. Here, we find that the VA had a reasonable basis to cancel the RFQ. The record shows that the agency is considering whether the cleaning and janitorial services required under the solicitation should have been procured from an Ability 1 vendor. Although it is not clear whether this rationale was part of the agency's initial decision to cancel the solicitation, our office has held that a new or additional rationale justifying the cancellation of a solicitation provided by an agency during the development of a protest is reasonable so long as it would have supported cancellation had it been advanced originally. Additionally, the contracting officer states that the cancellation of the RFQ was reasonable because vendors were misled by inaccurate information in the solicitation regarding the square footage required to be cleaned by the vendor. As stated above, the RFQ listed the square footage in gross terms, instead of net. The contracting officer states that the required square footage should have been listed in net terms for the vendors to accurately quote the requirements. Contrary to the protester's contention, the contracting officer notes that this issue was not resolved by the site visit, as the vendors were not shown the complete areas of the requirement. Finally, to the extent that the protester contends that the agency's action in canceling the solicitation was unreasonable because it was responding to untimely agency-level protests, our office has consistently held that agencies may take corrective action in response to issues that were not raised in a protest, or in response to untimely protest issues, even if that is not until after proposals are submitted and the protester has incurred costs. Here, we note that the record contains evidence that the integrity of the procurement system would be prejudiced if the RFQ were not cancelled. The agency has stated that if the solicitation had not been cancelled, the unfair environment would have tainted the integrity of the procurement and the VA would not have contracted for the services needed. TaxSlayer argues that the IRS's stated rationale for canceling the RFP that the agency was unable to reach a proper source selection decision based on the solicitation provisions addressing software evaluation was unreasonable because it fails to explain how the RFP prevented the IRS from making a proper award decision, or how the RFP was otherwise flawed. Specifically, the protester contends that the cancellation decision was based solely on the agency's inability to reach a proper source selection, which the protester asserts did not stem from any RFP defect, and therefore should have been resolved by a new evaluation. For the reasons discussed below, we conclude that the agency's decision to cancel the solicitation was reasonable. In a negotiated procurement such as this one, the contracting agency has broad discretion in deciding whether to cancel a solicitation and need only have a reasonable basis for doing so. A reasonable basis to cancel exists when, for example, an agency determines that a solicitation does not accurately reflect its needs. A reasonable basis also exists when an agency determines it needs to revise evaluation standards to ensure fair and equal competition. In addition, the prospect of increased competition and the lower prices which often result generally provides a reasonable basis for an agency to cancel a solicitation. So long as there is a reasonable basis for doing so, an agency may cancel a solicitation no matter when the information precipitating the cancellation first arises, even if it is not until offers have been submitted and evaluated. Where the record shows that there was a reasonable basis to cancel the solicitation, we will not find that the agency abused its discretion, even though it could have taken a different course by amending the solicitation. TaxSlayer argues that the testimony provided by the contracting officer and TEP chair supports the protester's position that the agency's asserted basis for canceling the RFP concerned evaluation issues, rather than a defect with the RFP. While the protester is correct that the contracting officer and TEP chair testified regarding the agency's evaluation problems, the contracting officer and TEP chair, however, also testified that the RFP's requirements and software evaluation criteria did not reflect the agency's needs. As discussed above, the RFP stated that the agency would evaluate a vendor's software to identify that the functionality and ease of use of the software are in accordance with the PWS's software, operation, regulatory and security requirements, and that, based on this evaluation, the vendor's software would be rated as fully meets, mostly meets, partially meets, or does not meet. As also discussed above, the contracting officer found that the agency's initial usability testing failed to comply with the RFP's requirements because it did not include consideration of whether the ease of use of the offeror software was in accordance with the PWS's software, operation, regulatory and security requirements, and it did not rate the offeror's software using the adjectival ratings contained in the RFP. The record also reflects that the contracting officer also expressed concerns regarding the validity of the agency's subsequent evaluation of the ease of use of the offeror's software, using the technical evaluation tool, even though the contracting officer believed that the evaluation tool complied with the evaluation requirements in the RFP. Specifically, in a statement submitted in response to the protest, the contracting officer explains, as relevant here, that after receiving the revised software evaluation results from the TEP, he remained concerned about inconsistencies in the ratings of evaluations and potential solutions for obtaining the requisite usability testing that complied with the terms of the solicitation. In this regard, as explained during testimony provided by the contracting officer, the RFP failed to provide a meaningful evaluation of usability. Specifically, the contracting officer and TEP chair testified that, while the RFP required the agency to evaluate whether the functionality and ease of use of the software are in accordance with the PWS's software, operation, regulatory, and security requirements, the PWS requirements focused only on the functional capabilities of the software and failed to capture the agency's needs regarding ease of use. In this regard, the contracting officer and TEP chair explained that the agency's ease of use needs regarding the VITA program include, for example, whether a particular vendor's software is easy to navigate or permits testers to transition between screens. They also testified regarding the importance of the software's ease of use to the VITA program in light of the program's reliance on volunteers. In addition, the agency's deputy director, Office of Information Technology Acquisitions, who supervised the contracting officer for this procurement, testified during the hearing regarding the agency's decision to cancel the solicitation. Specifically, the deputy director discussed the agency's concerns regarding its inability to evaluate the usability of the software, stating that usability is a matter of time and quality for completion of tax returns, and was not addressed by our solicitation or evaluation factors. He explained that as written, we did not know that the solicitation and resulting contract would meet the IRS's needs, and that the agency considered this to be a material flaw in the solicitation. To the extent the protester disagrees with the agency's judgment concerning its needs and how best to accommodate them, such disagreement does not demonstrate that the agency's judgment was unreasonable. Contracting agencies have broad discretion to determine their needs and the best way to meet them. Accordingly, based on this record, we find the protester's argument is not supported by the record. The record here supports the IRS's contention that the RFP's requirements and software evaluation criteria were not adequately structured to provide the agency with a meaningful basis to evaluate the ease of use of the software as necessary for the VITA program. We therefore conclude that the agency reasonably determined that the solicitation did not reflect the agency's needs. In addition, the record indicates that the agency believed that revising the RFP and PWS may lead to increased competition, which is supported by the fact, as discussed above, that 3 of the 5 proposals originally received by the agency were deemed non-responsive and excluded from the competition. Under these circumstances, we find that the agency's determination to cancel the solicitation was reasonable. Where a solicitation no longer accurately reflects an agency's requirements, and resolicitation could result in increased competition, cancellation of the solicitation is appropriate. In sum, we find no basis to object to the agency's cancellation of the RFP.